Hey, it's Patriot Smoothie. Today we had a check-in appearance for Chris Barber and Tamara Lich concerning their matter, their trial here in Ottawa. Present for Mr. Barber was Miss Eunice and Miss Magus appearing virtually, and present for Miss Lich were Mr. Granger and Mr. Greenspun in person, and also the Crown was there, and presiding was Justice Heather Perkins McVeigh. It was an interesting appearance. We learned a few things, not very much. It lasted maybe about 30 minutes, started a little bit late, ended around 2:40. The next appearance, next anything we have for this trial is this Friday at 12 p.m. in courtroom, I believe it's 12. So I'll be there for that to check in and tell you whatever's going on there. No further dates at this time for any progression of the trial. No trial dates at this time. And it's interesting because they were talking about next week as possible dates for the continuation of the trial, and it was made apparent that Mr. Granger has previous commitments, and that they've been trying to resolve, and that those commitments have been trying to be resolved in the background with the Crown, because it's a matter obviously that concerns the Crown, I'd assume. And it seems that Mr. Greenspan wanted to make it clear that the Crown has not made their intentions, whether they're going to resolve the matter or not, known. So the entirety of next week cannot be booked because Mr. Granger has to go and do this other commitment. Now, maybe if the Crown could resolve that, then it couldn't be a problem. It could be time that could be used for this trial to go day 27 and onwards. Day 27, that's what the next day will be. We finished day 26, and we're moving on to day 27 whenever the trial of Chris and Tamara continues, which is ridiculous. Day 27 of what is effectively a mischief trial, a bunch of different mischief type offenses, counseling mischief, counseling intimidation, which is basically because people honked their horn or something, and that was supposed to have intimidated the Prime Minister of Canada, who was at his cottage insulting these people. So that make it make sense to me. In any case, the evidence presented in trial so far has been extraordinarily weak. It has not painted the picture of criminal masterminds or people who had total control, kings and queens of the convoy, if you will, between Chris Barber and Tamara Lich respectively. Certainly they weren't. There were groups marching to the beat of their own drum. Perkins McVeigh has acknowledged that there were several groups, 18 or 20 even, all doing their own thing, really, whereas Chris Barber took every opportunity he could to actually try and encourage people moving out of residential areas, remaining peaceful, thanking police for their cooperation and hard work. And that's the evidence we've seen presented by both the Crown and the defense. Also, the majority of the evidence is about the convoy at large, not about the two accused. So there's a lot of questions here, a lot of a weak Crown case being made, no doubt, and certainly doesn't justify 2 to 10 years in penitentiary, let alone the charges themselves at this point are beyond questionable. And I think that the parties are all aware to that. They're all alive to that reality, all of them. And I'd like to add, so Friday at 12 p.m. we'll have another to be spoken to, and maybe we'll get another trial date at that time. And again, Mr. Greenspan wanting to be very specific, very, very clear, that it is the Crown who is not letting them know, Mr. Granger know the intention of resolving that matter next week, and that they've been talking about this for weeks, and still the Crown hasn't said anything about it. We got another thing. So they're talked about one day and beyond next week, which would be the week. So November 11th, Remembrance Day is Saturday, the 12th is Sunday, so it would be the week of the 13th they talked about, or maybe moving on from the week of the 14th, and the Crown asked for the 14th and basically said that if we don't get the 14th and then suddenly the rest of that week becomes available, those dates that are being held by trial coordination may no longer be held. So they tried to give this reason, and it sounded like the judge did not abide those reasons, did not agree with them, and said, no, we'll come on Friday and we'll talk about it, more or less is what everyone agreed to. It sounds like the judge will be, Justice Perkins McVeigh will be appearing virtually for that on Friday, but I will be there in courtroom 12 in person at noon, and it sounds like also some of the other counselors will be appearing virtually as well, but we'll maybe get another trial date. They have to adjourn until something, so they're adjourning to Friday at this point. Next week up in the air. They were also discussing the possibility of a single day, November 20th. Hard to know. Maybe that sounds the most promising of all the dates for the continuation of the trial. And then they were talking the week of the 27th to December 1st, and still don't really know the situation there. So I'll update you as soon as any of this is concrete. I don't like giving dates because every time I've reported on a date, it's vanished into thin air and never to be seen again. So I feel very hesitant to report any kind of dates based on how many times the dates I have reported have changed or what have you. It's just not concrete at this time. When it does become concrete, when we do have confirmed dates, you'll be the first to know. I will come and tell you. Another interesting thing happened today. There was so as you may have been following, you know about exhibits A, B, C, and D. concerning different things. Exhibit A was ordered to be produced by Justice Heather Perkins McVeigh, and Exhibit A is a list of instructions that were given to, I guess, the entirety of Ottawa Police concerning how to update their phones. We heard in cross-examination from OPS PLT officer, Police Liaison Team Officer Nicole Bach, that her phone was wiped after an update. She tried to follow this set of instructions. She was not successful, and the phone, unfortunately, as she said, was wiped. She lost her data. Luckily, text messages between her and Christopher Barber, as Officer Bach was the main contact between Barber and the police, so she's a very important witness. Their text messages were recovered alternatively through Chris's phone. When they recovered his phone, were able to get all the data off of it. But other things on her phone, like other conversations with other people that can paint a very different picture of the situation on the ground in Ottawa than maybe is being alleged by the Crown, have been lost, as well as, unfortunately, her other things that could be on there. Who knows what was on there? Images, we don't know. It could have been anything. It's just, it's gone. It's gone. And so the defense reasonably said, we want that list of instructions. And after some heavy legal arguments, Justice Heather Perkins McVeigh, some time ago, maybe a week or two now, agreed with the defense and ordered that produced, and it was. So they got those instructions from the Crown, from the police to police about how to do this update. And originally the Crown was arguing that it was clearly irrelevant, and obviously Justice Heather Perkins McVeigh did not agree with that argument and ordered it disclosed. Now, there was another argument attached to that concerning Exhibit C, and Exhibit C was the emails between OPS PLT Sergeant Feng Li and OPS PLT Officer Nicole Bach and others. And there's different emails between police, and the Ottawa Police Service was claiming through their legal team and the Crown solicitor-client privilege over those communications between police. So Justice Heather Perkins McVeigh had to make a ruling on that. Took a little bit longer than the Exhibit A clearly irrelevant / third-party argument, but she did make a ruling, and she said what she decided was that she decided some of the portions do qualify as solicitor-client privilege. She gave a lot of laws to justify her decisions, including O'Connor and Stinchcombe and others. And as all judges do when they make decisions, they justify it in the law. And she ordered the different portions. So she said, okay, there is some portions in here that is Crown advice being disseminated, but then there are some portions in here, she told the court, that are the opining of Sergeant Feng Li. So in that case, she ordered that to be disclosed. She said, she basically handed the Crown a new version with her redactions, where the solicitor-client privilege was redacted and the opinions of Sergeant Feng Li were unredacted. Now, we learned today, so that was, I think, Friday. It was some time ago, that order. So she said, okay, here's the new redactions, give that to the defense. And we learn now, which is November 8th, Wednesday, that the defense has not received Exhibit C at all. So what's the Crown doing? The Crown is making an application saying, no. We have your suggested redaction, but we have taken a highlighter, and in pink we've highlighted two tiny itsy-bitsy sections. Two tiny sections, Your Honor, where we would like you to reconsider your position and actually redact that, because we are claiming, OPS is claiming, that is solicitor-client privilege. So the judge made a decision, said, this is what's solicitor-client and this is not. And then OPS and the Crown looked at that, and the OPS apparently said, nope, that's solicitor-client privilege. I guess in a sense saying the judge is incorrect. And so, and now making another application through the Crown to try and redact it again, so that they can remove these quote two smaller pink sections. The defense hasn't gone any. The judge was like, well, did you give the defense anything at all in Exhibit C? No. So they haven't done that, and they're making an application to have it changed, to have the judge's ruling on that changed. So the judge, I guess, will look at that. Maybe we'll hear more about that argument concerning the pink amendments to the ordered disclosure, the pink amendments to the redactions ordered by Justice Perkins McVeigh, and I think maybe we'll elaborate on that on Friday. So that's the point. None of that has been disclosed to the defense yet. They're still fighting on Exhibit C, despite Justice Perkins McVeigh finding that the redaction should be changed and that some of those redactions do not apply concerning solicitor-client privilege. So we'll see how that plays out. But just to give you an idea of how every single inch of this seems to be adversarial, and every single inch of this, the progress is hindered. We see now that we have a judge's order that the Crown is making an application to amend. And I don't see how anyone but the Crown could be liable for the amount of time that this trial is taking. From Ottawa, I'm Patriot Smoothie. Have a great day. Let me know, by the way, in the comments down below what you think about all this. Don't forget to like and subscribe the video. It helps a lot. See you next time.